If you're filing a marriage-based adjustment of status case in the United States, you'll want to be sure that you were eligible. You want to avoid the mistake of filing an application if you do not meet all of the requirements. And I know you're thinking, of course, my case would get denied. But the reason I want you to avoid this mistake is because not only will your case be denied, but your case can be referred to immigration court for deportation proceedings. So the stakes of making this mistake are high. Especially in today's current political climate, it's extremely likely that you will be referred to deportation proceedings if you make a mistake and your adjustment application is denied. And I know you're thinking, right, but I'm going to do my research. I'm going to make sure that I'm eligible before I file my case. And that's great. And that's what you should do. And immigration law is complex and nuanced. And I cannot tell you how many times it's heartbreaking that I've had couples come to my office not realizing some of the issues that made them ineligible to file for adjustment of status. And they received the dreaded notice of intent to deny and denial notice, and later the immigration court deportation proceedings referral. Here's a few examples of times where couples thought they were eligible but ended up getting a denial. So the first one is that the petitioner wasn't a U.S. citizen. The petitioner was a lawful permanent resident. The rules are much different for a petition, an I-130 petition, and an adjustment of status case when the petitioner is not yet a citizen. Another issue that I've seen couples run into is that the immigrant beneficiary didn't actually have a lawful entry. So they did not enter, their most recent entry to the United States was not on a visa. Or the immigrant beneficiary had other issues in their immigration history. They had had contact with immigration and they were given something called expedited removal, which is a quick deportation that happens once you're in immigration custody. And so whenever a client has had contact with immigration, we always run their fingerprints and we always make sure that they don't have an expedited removal in their background, because this would make you ineligible for adjustment of status and throw you quickly into being deported. Other issues that I have seen couples make is not realizing that they needed a waiver of forgiveness. So if you've ever applied for a tourist visa in the past, if you were not fully honest on that tourist visa application, if you said you were married in hopes of having better chances of getting that tourist visa approved and you weren't actually married, that's fraud. And you need to file a waiver of forgiveness with your application. If you don't, the immigration officer is going to discover this upon reviewing your file and at your interview, and your case will be denied. So be sure that you meet the eligibility requirements.